Hello, my name is Michael Busby. I am a Texas family law and divorce attorney. In this presentation, I will go over with you proceedings that are contemporaneously or simultaneously occurring under the Uniform Child Custody and Jurisdiction Act, specifically Section 152-206 of the Texas Family Code, which is meant to deal with situations in which Texas courts and a court of another state are legitimately exercising jurisdiction at the same time. If a court determines jurisdiction as of the date the suit was filed, and therefore the issue is whether on a particular date a party files their suit in another state, then does the other state have jurisdiction simultaneously in conformity with Section 152 of the Texas Family Code. Except as in a temporary emergency jurisdiction, a Texas court may not exercise its jurisdiction under this section if at the time of the commencement of the proceeding, a proceeding concerning the custody of the child has been commenced in a court of another state having jurisdiction substantially in conformity with Chapter 152. An example would be in the Bark case where Colorado suit was filed first. Texas was precluded from exercising jurisdiction. If Colorado court has jurisdiction substantially in conformity with Chapter 152, there's an exception to this rule in which the proceeding in the other state has been terminated or stayed by the court of the other state because a court of this state is a more convenient forum under Section 152-207. A Texas court, before a hearing on a child custody proceeding, shall examine the court documents and other information supplied by the parties pursuant to Section 152-209. If the court determines that a child custody proceeding has been commenced in a court in another state having jurisdiction substantially in accordance with the chapter, the Texas court shall stay this proceeding and communicate with the court of the other state. If the court of the state having jurisdiction substantially in accordance with the chapter does not determine that Texas is a more convenient forum, the Texas court shall dismiss the proceeding. In a proceeding to modify a child custody determination, a Texas court shall determine whether proceeding to enforce the determination has been commenced in another state. If a proceeding to enforce a child custody determination has been commenced in another state, the Texas court may stay the proceeding for modifying pending the entry of an order of a court of another state enforcing, staying, or denying or dismissing the proceeding for enforcement, and joining the parties from continuing the proceeding or proceeding with a modification under conditions it considers appropriate. So where this happens is you have a foreign state that more recently I had a individual who took the child that was the subject of a Harris County order to Utah and would not return the child. So you at times can approach the local police and show the order, and some states will enforce that order through criminal statutes for interference with child custody. However, many states like Texas will tell you it's a civil proceeding and you need to take that order and domesticate it, and then you file either writ of habeas corpus or writ of attachment. And so that is where this provision contemplates a habeas corpus in a foreign jurisdiction or an enforcement, and therefore if you have a modification that also goes on contemporaneously, the court may stay the proceeding to determine whether or not there's an emergency basis in the state for which the enforcement or other proceeding has been filed, and therefore it could be that perhaps the primary parent was arrested for a DUI, and the other parent came to Texas to obtain the children versus them going to Child Protective Services, kept the children in the new state, then filed some type of domestication, and the other primary parent was incarcerated for a period of time. So you have different facts that can come up to justify the taking of a child to a new jurisdiction, and then the other parent gets her case dismissed or gets the underlying criminal case dismissed and then seeks to recover the children. Now, the UCCJEA requires the courts to communicate about simultaneous proceedings and to give each other a chance to rule on jurisdictional issues. If proceedings involving the same parties are pending simultaneously in a Texas court and the court of another state, the Texas court shall inform the other court of the simultaneous proceeding. The Texas court shall request that the other court hold the proceeding in that court in abeyance until the Texas court conducts a hearing to determine whether the court has jurisdiction over the proceeding. The exception mentioned above to a race to the courthouse, not affecting which court has subject matter jurisdiction under the UCCJEA, occurs when the court exercises default jurisdiction under Section 152-201A4. There being no home state and another party files a child custody proceeding in another state. This situation occurs with the first suit having been filed in a particular jurisdiction and the second suit having been filed in Texas. While both states may have significant connection jurisdiction under Section 152-201A2, the suit was filed, if it was filed first in the foreign state, not Texas, then Texas should not exercise jurisdiction unless the foreign state was terminated or stayed by the foreign state because Texas was a more convenient forum. The Texas court has is required to stay its proceedings and communicate with the foreign court unless the foreign court determined that Texas was a more appropriate forum, and then if the foreign state assumes jurisdiction, then Texas would be required to dismiss the underlying proceeding. Now, communications and coordination between the courts. The extraordinary feature of the UCCJEA, the Uniform Child Custody Jurisdiction and Enforcement Act, is the authority of courts in different states to communicate and cooperate with one another to minimize conflict and to make the correct decision. Judges and attorneys have to look at these communications and request for cooperation as formal proceedings, as there are record retention and disclosure requirements. A Texas court may communicate with a court of another state concerning a proceeding arising under Chapter 152. Courts may therefore communicate whether it be to resolve a jurisdictional determination or an enforcement issue. Parties may participate in these communications. If the parties are unable to participate, the court must give them an opportunity to present facts and legal argument before a decision on jurisdiction is made. Communications between courts on schedules, calendars, court records, and similar matters may occur without informing the parties, and the courts do not need to make a record of the communication. All other communication between the courts require the making of a record. The parties must be informed promptly of these communications and granted access to the records. Beyond these communications, a Texas court may request the appropriate court of another state for assistance in jurisdiction and interstate enforcement issues. These requests may include asking the court of the other court to hold an evidentiary hearing, order a person to produce or give evidence pursuant to procedures of this state, or that an evaluation be made with respect to the custody of a child involved in a pending proceeding, forward to the court of this state a certified copy of the transcript of the record of the hearing, the evidence otherwise presented, and an evaluation prepared in compliance with this request, and also order a party to a child custody proceeding or any person having physical custody of the child to appear in the proceeding with or without the child. Also, if the court of another state makes such a request of a Texas court, the Texas court may hold an evidentiary hearing or enter such an order. A Texas court may assess against the parties travel and other necessary and reasonable expenses incurred under these sections according to Texas law. As with the records of communications between courts, a court has a duty to preserve records. A Texas court shall preserve the pleadings, orders, decrees, records of hearings, evaluations, and other pertinent records with respect to the child custody proceeding until the child attains 18 years of age. Upon appropriate request by a court or a law enforcement official of another state, the court shall forward certified copies of these records. My name is Michael Busby, and this video presentation was on simultaneous proceedings between sister states under the Uniform Child Custody and Jurisdiction and Enforcement Act of Texas, Chapter 152 of the Texas Family Code. Thank you for watching.